If you're thinking of bringing counsel attorneys to your boutique firm, there's a good chance you're making an insurance mistake and don't even know it. And the issue isn't the coverage and how it's going to be applied. The issue is how the application was completed when you applied for the insurance. From an insurance company's perspective, the applications are not just paperwork. It's a representation of how your firm actually operates. When of-counsel relationships are not described appropriately, problems tend to arise at the worst time, which is usually during a claim. I know how tedious it is to complete these applications, and most firms treat it like an administrative task, something to get through so that they can move on with their day and get their coverage bound. But insurance companies treat these applications that underwriting and claims decisions are made from. This difference matters especially when it comes to of-counsel attorneys, because carriers rely heavily on how these relationships are described when they decide on who is an insured, how coverage is priced, and how the coverage applies. And these mistakes are not obvious to boutique law firm owners. Some firm owners leave of-counsel attorneys off the applications because they simply don't view them as employees. Others will list them in the wrong role as a W-2 or an independent contractor without considering what the carrier defines as an insured. Another frequent problem is inconsistency with of-counsel attorneys. An of-counsel attorney may be listed one year, omitted the next, described differently the third year, and all of these changes are happening renewal to renewal. And none of these feel catastrophic at the time, but at the time of a claim, here's where the complications will show up. As a new boutique law firm owner, you just might assume that listing them as of-counsel is enough. Problem is that each insurance company defines an insured differently. Some include of-counsel automatically in the definition of who is an insured. Others require them to be listed specifically or even scheduled onto the policy. And some policies will tie coverage to supervision, representation, or how the attorney holds themselves out to clients. So what are these carriers looking for at the time of a claim? They're not just looking to the policy for definition of if coverage applies. They're reviewing the application, renewal applications, of-counsel agreements, firm websites, email domains, and how the attorney actually operates day to day. If all of these things don't line up, questions get asked. These questions slow down a claims process, complicate coverage determinations, and sometimes can lead to a dispute to see if does coverage even apply? As a new boutique law firm owner, I want you to understand that the biggest misconception when it comes to your malpractice insurance is that the renewals are automatic. This could not be further from the truth. You have to complete that application every year. Renewals are where carriers underwrite your risk all over again. If your firm structure changed, new of-counsel relationships, expanded responsibilities, increased access to systems, and the application doesn't reflect those changes, that's where the problem remains. Carriers will assume that the information on that application is accurate until otherwise proven. And so you don't need to over-disclose on these applications, and I'm not trying to create unnecessary concern, but I want you to be accurate and consistent when it comes to defining how your firm actually operates, who works under your name, how they interact with clients, and how the responsibilities flow through the firm. When applications, policies, and the reality align, claims are easier to handle for the insurance company and a better claims experience for you. At The Bunker, we're dedicated to helping boutique law firm owners get off on the right foot and understand the new risks they're taking on with starting their own firm. Click the link below to schedule some time so we can chat.